You're listening to The Voice of Russia with me, Juliet Speck. Judges at the European Court of Human Rights have recently ruled 3 British prisoners who were given indeterminate jail sentences in 2005 and subsequently not given proper access to rehabilitation courses had their human rights breached. They have now been awarded between £12,000 and £16,000 in compensation and costs. Indeterminate sentences for public protection were brought in under the Labour government in 2005. These sentences of no fixed length require the direction of the parole board if the prisoner is to be released. In May this year, the then Justice Secretary Ken Clarke scrapped them. Meanwhile, there are still more than 6,000 prisoners in England and Wales serving IPP sentences with no release date. To discuss the recent European judges' ruling, the legacy and prison rehabilitation, is Nick Hilroy, Programme Development Director from Penal Reform International, a non-governmental organisation working on penal and criminal justice reform worldwide. Matthew Evans, Managing Solicitor from the Prisons Advice Service, an independent registered charity. On the telephone, Noel Smith, who's an author and former prisoner and editor of Inside Time magazine, and UKIP Party Secretary Michael Greaves from the European Union Parliament in Brussels. First of all, I'd like to start with you, Michael, then. What do you think of the judge's ruling?
The ruling, I think, was actually entirely right on this occasion. Although the party that I represent is very critical of many aspects of the convention, this is an occasion when I'm happy to be in full agreement with them. You have a system of sentences which are designed to protect the public, and conditions are set for those who are given such sentences to achieve release. And then the resources to provide the courses and so on, which they need to fulfill those conditions, are simply not provided. That's Kafkaesque, I think, is a fair description of them. And there is notably a lot of criticism in the judgment. And indeed, there was criticism in the judgments of the courts in England of the Home Secretary and the Justice Secretary's performance of these courses. Not impressed, I think, is the best way to put it.
The same question to you then, Matt Evans.
Well, I think it's quite interesting about how the European Court differentiated itself from the domestic courts, because obviously this case had come up through the domestic courts before going to the European Court. And one of the issues that the domestic courts decided was that, as Michael says, all the courts were justifiably aggrieved at the failings of the Secretary of State in relation to his public law duties to provide reasonable courses and to provide a means by which these particular prisoners could show that they had reduced their risk in order to satisfy the parole board that they were now ready for release. But what the domestic courts felt was that the starting point, the primary object of the IPP sentence was to protect the public and not to rehabilitate. And so therefore for the domestic courts, Article 5, which is what was found to be in violation, only arose when the stage was reached that the detention was no longer necessary for the protection of the public, or where so long had elapsed between meaningful detention reviews that detention had been considered arbitrary. But the European Court, they actually looked at the enabling statute that allowed this particular legislation to come into force. And it was quite clear that when Baroness Scotland and the new Labour government had introduced this, that part of the process was that it was inherent in the way that the sentence was supposed to work in practice, that there was an element of rehabilitation. And actually what the European Court essentially viewed was that protecting the public and rehabilitation are two sides of the same coin, and that a real opportunity for rehabilitation was, in the court's words, a necessary element of any part of the detention which is to be justified solely by reference to public protection, and that detention for public protection could not be allowed to open the door to arbitrary detention.
Moving towards you then, Noel Smith, what are your thoughts on the judge's ruling?
I fully agree with it, to be honest, and I agree with quite a lot of what's been said so far about it. I mean, you can't really realistically put people in prison and tell them this is what you have to do to get out, and then not supply them with the materials to do that. I get letters all the time from people who are in prison who receive minimum tariffs of as little as 12 months, and they're still in 5 or 6 years later with no hope of getting out because they can't do the courses because they're not there. I think it's an outrageous situation that this country's got into. with the IPPs. And I'm not sure anyone envisaged that this was how it was going to end up when it was first brought out. I thought it was supposed to be used sparingly. But as you say, there are 6,000 prisoners in this country serving IPPs, at least half of which are over their tariffs and can't realistically have any hope of getting out of prison until they do the courses, and the courses aren't there.
Nick Hill, Roy, just to hear from you then from the Penal Reform International on your thoughts on the European judge's ruling and what impact this has internationally.
I think it has huge implications for our work globally. It's not just about the UK or about Europe. We look for good practice, we look for good judgments which can be used in other countries where these sorts of issues are being grappled with. And anything from the European Court as well as from the UN always helps us. We, Penal Reform International, wants to see an end to this practice of indeterminate sentences. We want to ensure that there's a realistic possibility of release for those who get life imprisonment. And in many countries, this is not happening. So often you get a maximum sentence, which is, life. It's there's no possibility of release. And this doesn't help. This makes society less safe. This idea that somehow society is going to be safe by locking people up needs to be challenged. The reason people are locked up is to allow them to undergo a process of rehabilitation. So the flip side of locking people up and keeping them behind bars is also to allow for a process of rehabilitation. And if that's not happening, then you're not really getting a safe society at all. So we want to see this judgment widely publicized, and we want to see the impact of the judgment in other countries where these sorts of practices are still going on.
You're listening to The Voice of Russia with me, Juliet Spare, and we're discussing prison rehabilitation and the scrapping of indeterminate sentences. Nick Hill Roy is Programme Development Director from the Penal Reform International. Matthew Evans is Managing Solicitor from the Prisons Advice Service. Michael Greaves is UKIP Party Secretary, and Noel Smith is an author and former prisoner. What impact psychologically do these IPP sentences have on inmates where there's no hope for rehabilitation?
Well, speaking from experience, I actually served an indeterminate sentence. My last prison sentence was a life sentence under the Two Strike Act, which was another piece of legislative folly that they had to scrap after so many years when they realised it wasn't working. But the psychological damage is vast, really, on prisoners. I've been reading figures lately that a lot of IPPs have the highest suicide rate in prison. The highest rate of mental illness through incarceration. And I don't think you can really calculate the amount of psychological damage this has on the families as well of the prisoners. Don't forget, these are prisoners whose crimes would have warranted the minimum tariff that they're getting, which in some cases is 12 months, in some cases 2 years imprisonment, and basically they're then stuck in a limbo that they can't get out of, having served the time that the judge has set for punishment. They can't get out, and their families suffer every year. I know what it was like with my family. I got an 8-year tariff, and as a model prisoner I was released in 12 years. So I went 4 years over my tariff, simply because there wasn't enough judges to do parole boards. And you can't have a system of imprisonment in any civilised country where you remain in incarceration. It depends on budgetary matters, or it's just not right. You can't say I'm jailing you for the protection of the public, go in and change your ways, and then just forget about people. The psychological damage is vast, I should imagine.
Matt Evans, you work within the prison system as an independent charity. What are your experiences with the inmates inside who are looking for some way out of their predicament?
Well, I think just going back on Noel's point about the idea that the IPP sentences were going to be used sparingly, I think if you look at the way that they were introduced, this was always going to be a perfect storm for a disaster. I mean, when IPPs were introduced, it was as a precursor to what had happened with the Halliday report, which had talked about the idea of moving in certain situations for, persistent criminals away from just desserts punishment, which was designed to look at, punishment as compared to the severity or gravity of the crime, and to move towards then looking at kind of relevant and more recent convictions, and that being part of the sentencing process, and the IPPs were the kind of ultimate outcome of that. But when the IPPs were introduced, I mean, there were 95 qualifying offences that could be committed, and that would mean to say that you would fall within an IPP sentence, and they range from manslaughter to indecent assault. And in addition to that, there was then a presumption of dangerousness where a further 58 offences that had previously been committed by somebody who had committed another serious offence could be considered, and they included anything from criminal damage. So it was always going to be the case that a huge number of people were going to be caught within the IPP system. And what then happened was that the government decided that, on their statistics, that this would be a resource-neutral sentence. In other words, that there would be few people caught within it. It wouldn't require very much money to be ploughed back into the system. And so they therefore didn't resource any of the authorities that were charged with dealing with IPP sentences. So you found that judges were giving out IPP sentences like confetti because almost they had no choice. They were mandatory in certain situations. You had a probation service that were then having to deal with a whole range of lifer cases. And there's lots of inspectorate reports which suggest that actually when they were doing their pre-sentence reports, which is designed to assist the judge in sentencing, that actually they were very long on description and very short on analysis, and often didn't take individuals' needs into account in terms of, for instance, prisoners or people that were coming up before the courts who had learning disabilities or mental health issues and who were never going to be able to comply with an IPP sentence in any event. And then on top of that, you had complete gridlock. You had a prison service that was completely unable to deal with the increase in lifers, who had no understanding of even what an IPP sentence was. I mean, we used to get calls and deal with IPP sentence prisoners, and the first time that they were even aware that they were actually serving a life sentence was when they were introduced to the lifer manager at their particular prison, and they were told, "I'm the lifer manager, you're on a life sentence." They said, "No, I'm not, I'm on an IPP sentence." None of this was explained to them. And then as you progressed through, there were no resources in relation to offending behaviour courses, and then finally there was gridlock in relation to the parole board, which around the time of the introduction of the IPP sentences was so risk adverse and had been, politically charged by people like John Reid, who had said basically the parole board are releasing too many prisoners, therefore please don't release too many prisoners or I'll take decisions for you, that the parole board statistics in relation to release went down from over 50% to around 30% over the intervening years. So this was always going to happen, and the reality is that you're, as Noel says, you're now left with over 6,000 IPP prisoners. That is 1 in 15 of the prison population, which is a staggering statistic, and that costs £40,000 each year per IPP prisoner.
Michael Greaves, what lessons then does the UK government need to learn from this? And Chris Grayling, the Justice Secretary, says he wants to appeal the European Court's decision.
If I can just slightly take one point that was made about whether there should or should not be a system of sentences which protect the public. In my view, there absolutely should be a system whereby sentences can be passed for the protection of the public. I have represented people both in the domestic courts and in the war crimes courts in The Hague who were thoroughly dangerous and a threat to public safety. Those people must be kept away from the streets. So you have to have a system. I don't think the system that they've come up with is a good one. It's far too complex and far too technical. The government has to revisit this, and they have to come up with a system which produces a system which can protect the public, which has the confidence of the public, but which also addresses the prospect of rehabilitating some prisoners. And there are some prisoners who can't be rehabilitated because they don't want to be rehabilitated. So you have to factor that in as well. Some people simply don't, and I've represented people who were simply not interested in that sort of thing. You do have to have a system which does not lead to psychological damage of prisoners. That's plainly right, plainly fair in a decent society. But as to appealing the judgment, I think Mr. Grayling would be most ill-advised to do it. I think that's not, they just need to go back to the drawing board and come up with a better system.
Nick Hilroy, what system would you like to see and what would work? It's an incredibly confusing system.
The program that we promote, and which is based on the international covenants on civil and political rights, as well as the Universal Declaration of Human Rights, is that all prisoners should be treated equally and humanely. Now, I'm not making this up. This is something which is part of our internationally accepted set of conventions, to which, incidentally, the UK has also signed up. So treating all prisoners equally and humanely, what does that mean? It means even those who are on who are on life imprisonment, or those who have indeterminate sentences, and others, dangerous or otherwise, need to be given the opportunity to rehabilitate, to show progress, to be given access to programs of education, individual treatment programs, anger management programs, counseling, therapy. That is what we want to see happening. Now, you're not going to get that if your prisons are bursting at the seams, where your staff are under pressure all the time, just in terms of managing the day-to-day requirements of security and running the prison service. So you really do need to look seriously at how are you going to, first of all, reduce numbers, and what does that mean in terms of providing rehabilitation services and assessment, individualized programs for prisoners who are categorized. So those who are less likely to offend versus those who are more likely to offend. That's the purpose of a corrections program. That's the purpose of the penitentiary service. And can I just remind people that under a specific recommendation, Recommendation 23 from 2003 of the Committee of Members of the Council of Europe on the management by prison administrators of life sentences and other long-term prisoners, one of the fundamental points raised here is this idea of progression, that there should be individual assessment of needs and risks, which should be linked to the possibility of progressing through the different security levels and opportunities available in the prison system, and ultimately of return to society with or without supervision. That's what we're aiming for. That is what should be the aim. Now, you might get exceptions. You might get a few people who will not be rehabilitated, who don't want to be rehabilitated. I would suggest that that's a very small minority, and what we have a danger of doing here is making up, a huge system which actually doesn't do any favors to a majority of those who might actually benefit by being given access to these rehabilitation programs.
You're listening to The Voice of Russia with me, Juliet Spare, and we're discussing prison rehabilitation and the scrapping of indeterminate sentences. Joining me around the table is Nick Hill-Roy, Programme Development Director from Penal Reform International, and Matthew Evans, Managing Solicitor from the Prisons Advice Service. And on the telephone, Michael Greaves, who's the UKIP Party Secretary, and Noel Smith, an author and former prisoner. Noel, I'd just like to come to you. What sort of rehabilitation did you experience in prison?
I've spent over 33 years in the British prison system, and I can honestly, hand on heart, say that there is no rehabilitation offered in the British prison system as standard. If you want rehabilitation in the British system, you have to search for it, and believe me, there is not a lot of it. I actually applied for a voluntary prison called Grendon, which works on therapeutic lines, group therapy, after a tragic circumstance in my life with my family outside. I decided to change my life, and then when I looked for rehabilitation, it was few and far between. You have to actively seek rehabilitation out in the prison system. And I've got to say, there was talk earlier on about anger management and various offending behaviour courses. In my experience, none of these courses work. They're all tick boxes. For example, on my last sentence, which was a fixed-term sentence, I had to do anger management, thinking skills, relationship skills, and all that 3 or 4 times. It's just a cash cow for the psychologists in the prison system. Once you do one of those courses, you tick the boxes, and they make you do it again 3 or 4 years down the line, so you remember your answers, and that's how they look as though they're actually helping when they're not. I've got to say as well, just as an aside, on my previous sentence, which was for armed robbery, I ended up doing the enhanced thinking skills course, which is, they keep changing the name of it in prisons, but it's held up in high esteem by a lot of psychologists and people involved in prison as a good offending behaviour indicator. And when I came out, I teamed up with 3 other people who had been in prison and had all done the enhanced thinking skills course, and we were all bank robbers, and we used things that we found in the course in the course of our crimes. So, those courses don't work. They've certainly never worked for me, and I've never met anybody who they have worked for. And to find rehabilitation in prison is very difficult.
On Noel's point about offending behaviour courses and the idea of rehabilitation, I mean, firstly, he is absolutely correct that you have to look long and hard to find these particular courses. And my experience, things like Healthy Relationships Programme, which is designed to meet issues around domestic and personal violence, there is often a 3-year waiting list to even get on those particular courses. And often these courses are introduced, as Noel seems to suggest, on a kind of periodic review. So the classic example would be the Cognitive Self-Change Programme, which is designed to kind of combat or look at instrumental violence. And that was introduced and is seen to be a kind of golden bullet by both the Parole Board and the Prison Service in relation to assessing and reducing risk of violence. But the reality is, like most of these courses, is that none of them are evaluated. They come in and they're introduced without any proper evaluation, and then they're just rolled out. And then after 2 or 3 years, the name changes and/or they're quietly put to one side, and a new course is introduced. And so it's very difficult to have any real certainty that any of these courses are doing what they are supposed to do, which is essentially change people's thinking and behaviour in relation to the protection of the public. And just finally, on the European Court judgment, I just want to make it clear that what the European Court has not ruled is that the whole concept of indefinite preventative detention is unlawful. They have simply said that within the context of the IPPs and the particular problems with the IPPs, that it had become such that detention had now become arbitrary.
Behind all the legal speak, though, we've got people who are saying these courses aren't up to scratch. Nick Hilroy, what's your reaction to that when you want to see, obviously, the future of prisons internationally being able to offer these rehabilitation courses?
It's very depressing to hear from Noel about the fact that these courses are tick box exercises. Having said that, I think there is positive elements which can be looked at and which should be promoted. I think, in addition to what Matt said about Chris Grayling sort of taking a step back and saying, look, let's clear up this mess, he could do something else, which is to look at Ken Clarke's proposals, which he was trying to sort of promote as Justice Secretary, to really push the idea of rehabilitation. It's a pity that's gone on the back burner. Chris Grayling has made clear he's not that interested in that issue. He sees, reduction of overcrowding as being something linked to the return of foreign prisoners, and that's what he wants to sort of really look at. I think that's a mistake. We really need to look at this whole issue of rehabilitation and what can we do. Charities do provide good interventions in prison services, not just in this country, but also overseas. Unfortunately, over the years, we've seen there's been a decline in resources, in the availability of services that can be made available. I don't think it's just the responsibility of the prison service necessarily to be doing rehabilitation. They need to work with other stakeholders in the system. They need to be able to link up with charities, with service providers who can actually help provide the professional inputs and interventions that are needed. Which is not to say that people will always get access to these things, simply because the overcrowding issue has to be addressed as well. In the past, Penal Reform International has promoted certain innovative exercises in other countries. For example, in Ukraine, we worked with the university departments to provide psychological and psychiatric services using students working with juveniles in the pretrial detention facilities in Kiev. That's just one example where you try and circumvent the resource issue by looking at what other connections could be made with universities, for example, with other service providers, and so on. We are very clear that the way forward is through providing proper rehabilitation, through reducing overcrowding, and through scrapping indeterminate sentences and making sure that determinate sentences are the way, with the possibility of release and with individualized programs to allow people to be rehabilitated.
Michael Greaves, what recommendations would you make for rehabilitation then?
It's important that we have realistic and effective programs for rehabilitation. And having practiced in the criminal courts, I know only too well that much of what is done in prisons is ineffective. What we mustn't do, though, is lose sight of what the purpose of prisons is. It's not merely to rehabilitate. We do have to remember that they exist to punish people, they exist to deter people, and in part exist to protect the public from the activities of criminals. So your listeners mustn't lose sight of that purpose. But rehabilitation is a desirable end, but it must be effective. And sadly, a lot of what goes on is not terribly effective.
Finally then, Noel, I'd like to hear really your final thoughts on what sort of rehabilitation you think prison needs.
To be honest with you, if I had all the answers, I'd be applying for the job of Home Secretary. As far as I'm concerned, the purpose of prison is to hold people who have committed crimes against society for a set period of time when the law deems they should be released. But I will say this, if you're going to put people in prison and do nothing while they're in there except ineffective courses, bang people up 23 hours a day and just leave them to their own devices, then you've got to stop moaning about the reconviction rates, because people are reconvicting. People are getting convicted again after they come out of prison, because you come out of prison worse off than when you went in. You might have a home and a job before you go to prison. You won't have them when you come out. You get paid £46 discharge grant. There is no aftercare. You're turfed out the gate with your £46 in your hand. That's supposed to last you 2 weeks. Is it any wonder that people come out of prison and find that they go back to crime? They're taught nothing in prison. They mix with a load of other criminals who give them information on criminal activities. You know, it's just a fact, and people are not willing to look at the basics of prison. Prison should be for only the most dangerous people to society, people who would actually cause serious harm to society. It shouldn't be for people who haven't paid their council tax, or women who haven't paid their television licence, or people for shoplifting. If you really want to make prison work, you should actually send the most dangerous people to prison, and then once they're in prison, try to teach them a different way. I've spent 33 years in prison, and all I learned from prison was how to commit more crimes and how to actually hate society more, because that's all you do. You just warehouse people, lock them all together in one big place and give them their bitterness to feed on, and that's it. And when they're released, obviously they're going to go back to crime. Very few do not go back to crime. And also there's a massive heroin problem in our prisons, and that should be addressed almost immediately, because people are going into prison quite clean, getting addicted to heroin, coming out and having to feed their habit by committing more crime. We've got to look at the basics of prison. You know, ideally scrap it and start again. We can't do that, but that would be the ideal.
Nick Hill, what can the British Prison Service learn from other countries around the world?
The deprivation of liberty is the punishment. I mean, that is what we need to realize. Prison should only be used for the most dangerous people, and we need to look at how we use other measures of sentencing, other measures of punishment, if you want to call it that, than using prison. And community service has been mentioned. There are other ways in which people can be treated. You don't want mentally ill people. You don't want them in prison. You want them to be given treatment for their mental illness. Those who have a drug problem, you don't want them in the prisons. You want them to be on drug rehabilitation programs. I think a number of other societies are beginning to understand that you can't just use prisons to lock people up. And there has to be an element of rehabilitation which has to be built into the purpose of the prison service.
I'd like to thank all my guests, Noel Smith from Inside Time magazine, Matthew Evans from the Prisoners Advice Service, UKIP Party Secretary Michael Greaves, and Nick Hill-Roy from Penal Reform International.
For those who are given such sentences to achieve release, and then the resources to provide the courses and so on which they need to fulfill those conditions is simply not provided. That's Kafkaesque, I think, is a fair description of them. And there is notably a lot of criticism in the judgment, and indeed there was criticism in the judgments of the courts in England of the Home Secretary and the Justice Secretary's performance of these courses. Not impressed, I think, is the best way to put it.
The same question to you then, Matt Evans.
Well, I think it's quite interesting about how the European Court differentiated itself from the
You're listening to The Voice of Russia with me, Juliet Spag. Judges at the European Court of Human Rights have recently ruled 3 British prisoners who were given indeterminate jail sentences in 2005 and subsequently not given proper access to rehabilitation courses, had their human rights breached. They have now been awarded between £12,000 and £16,000 in compensation and costs. Indeterminate sentences for public
domestic courts, because obviously this case had come up through the domestic courts before going to the European Court. And one of the issues that the domestic courts decided was that, as Michael says, all the courts were justifiably aggrieved at the failings of the Secretary of State in relation to his public law duties to provide reasonable courses and to provide a means by which these particular prisoners could show that they had reduced their risk in order to satisfy the parole board that they were now ready for release. But what the domestic courts felt was that the starting point, the primary object of the IPP sentence was to protect the public.
Prisons Advice Service, an independent registered charity. On the telephone, Noel Smith, who's an author and former prisoner and editor of Inside Time magazine, and UKIP party secretary Michael Greaves from the European Union Parliament in Brussels. First of all, I'd like to start with you, Michael, then. What do you think of the judge's ruling?
The ruling, I think, was actually entirely right on this occasion. Although the parties I represent is very critical of many aspects of the Convention, this is an occasion when I'm happy to be in full agreement with them. You have a system of sentences which are designed to protect the public, and conditions are set for
protection were brought in under the Labour government in 2005. These sentences of no fixed length require the direction of the parole board if the prisoner is to be released. In May this year, the then Justice Secretary Ken Clarke scrapped them. Meanwhile, there are still more than 6,000 prisoners in England and Wales serving IPP sentences with no release date. To discuss the recent European judge's ruling, the legacy and prison rehabilitation, is Nick Hilroy, Programme Development Director from Penal Reform International, a non-governmental organisation working on penal and criminal justice reform worldwide. Matthew Evans, Managing Solicitor from the